Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Sawaya. To my left, we're glad to have Judge LaRue here from the 7th Circuit sitting as an associate judge with us this week to help out. We have both civil and criminal cases on the docket today. The civil cases, each side will have 15 minutes. Criminal cases 15 minutes, civil cases 20 minutes. The appellant can reserve as much time for rebuttal as they like. We will take a break after the first two cases. The lawyers here are invited to join us in the lawyers' lounge for coffee if they want during the break. If you've got cell phones or pagers, please make sure they're turned off so they don't interrupt us during the arguments. First case on the docket is HEBENSTREIT versus State.
May it please the Court? If I could at this time, I'd like to reserve 2 minutes for rebuttal. My name is Lisa Jama, and I'm the Assistant Public Defender representing the appellant Samuel HEBENSTREIT. Mr. HEBENSTREIT is appealing a circuit court order dismissing his petition for writ of prohibition. That petition was filed to preclude the county court from convening a hearing at which he would recall the jurors who had found Mr. HEBENSTREIT not guilty of driving under the influence to give testimony regarding that verdict. At the trial on April 17th, 2000...
Why isn't this case moot now that that hearing has occurred? And why isn't the remedy appealing from whatever judgment or sentence is imposed?
Judge, the reason it's not moot is because no formal judgment has been entered. Only the verdict was changed by the jury where they scratched out not guilty and put guilty. But the judge did not enter judgment and did not sentence Mr. HEBENSTREIT because Mr. HEBENSTREIT was not present after being acquitted and released to go hence without day. He did not come back for the evidentiary hearing. So the judge set sentencing off to May 30th, and that's when, right before that, the circuit court issued an order to show cause why it wasn't moved.
Didn't you simply request that the motion for prohibition be directed towards the hearing to prevent any further hearings or to prevent the jury from coming back, as opposed to entry of a judgment or sentence?
Correct. That's true, Judge, because at the time the petition for writ of prohibition was filed, we didn't have a hearing and we didn't have the verdict.
The hearing has already been held, right?
The hearing has already been held. What hasn't happened...
Pardon me, isn't this a very narrow issue concerning the writ of prohibition itself?
Yes, you're right, Judge, it is.
And isn't the writ of prohibition essentially to stop the evidentiary hearing with the jury from occurring?
Judge, our position is that initially it was the evidentiary hearing, but what came from that hearing was a change in the verdict, and then which wasn't anticipated when the petition for writ of prohibition was filed. The verdict was changed. The judge did not enter a judgment, did not sentence Mr. HEBENSTREIT in absentia, and set off sentencing. So, yes, the evidentiary hearing has occurred, and a prohibition to stop that would be moot. But what isn't moot is the petition to stop the judgment and sentencing from occurring.
Could you file a separate petition for prohibition directed towards the sentencing and the entry of the judgment?
Judge, that's a good question, but with the circuit court's order, the circuit court specifically said that presumably sentencing had occurred.
And it had not.
And it had not, and then it said that our only remedy was an appeal of the judgment and sentence, a final appeal of the judgment and sentence. I think that was the exact wording of the circuit court's order.
But since and the sentencing has not occurred to this day.
That's correct.
Is that because the defendant didn't appear when he was supposed to, or?
Yes, Judge. The defendant got notice by mail.
Was ordered to appear but didn't appear, so there was no sentencing, is that right?
That's correct. He was acquitted. He left the courtroom with his court minutes saying he was acquitted, and
I know, but subsequently, after the hearing, he was ordered to appear and he didn't appear, did he?
That's correct, Judge. So there's a capias that's outstanding for Mr. HEBENSTREIT at this moment. Our office represented him, at the trial level, and Mr. HEBENSTREIT hasn't come back since that day. Mr. HEBENSTREIT apparently was served by mail. I think that there was no other formal notice or summons given to him. But what we would argue is that because the circuit court has limited us to filing an appeal of the final judgment and sentence, it's actually precluding us from getting from filing the petition for writ of prohibition on the sentencing. Even though the circuit court's order claims to not want to address the petition because it's moot, it also sort of does and says, well, sentencing has probably occurred, and as such, there is an adequate remedy at appeal. So we would argue that we are now precluded from having a writ of prohibition in this case, and our only remedy is an appeal of the final judgment. And at this point, to wait for the formal judgment to be entered and a sentencing for on Mr. HEBENSTREIT would be too harmful to allow when the circuit court does have the jurisdiction to prohibit that.
Did your writ of prohibition have some sort of general language in it about not showing up at all? I thought I remembered an argument in your briefs that the reason it's not moot is there was at least some language in the petition that could be read as we want to prohibit any requirement to show up for anything after the acquittal.
That's correct, Judge. At the time that the county court issued the order recalling the jury, it also did a notice of hearing requiring Mr. HEBENSTREIT to be present for that hearing, and we filed the petition for writ of prohibition to prevent and added that language to prevent Mr. HEBENSTREIT from having to appear
at any time or at the evidentiary hearing. I guess that's the question. You have the petition there, or do you
Yes.
know the exact language you used as to what you were trying to prohibit?
It does say from requiring his presence at said hearing, which I would assume is the evidentiary hearing. However, Judge, because the petition for writ of prohibition was addressed to the evidentiary hearing at the time, the circuit court finally issues the order on June 21st, 2006, after the sentencing hearing was supposed to occur, without doing another order to show cause why it's not moot. And the reason we would argue that it's now prohibited us from filing a petition for writ of prohibition, even as to the sentencing, because the order addresses the fact that he had not been sentenced.
When you filed your petition, did you also request a stay of any kind to prevent any further, action by the trial court?
Yes, Judge.
And the trial court denied your motion for stay?
Yes, Judge. I had filed a stay, actually, with the circuit court. The circuit court then said later on that it should have been filed in the county court, but at the time of the evidentiary hearing, I did move the court to stay the
All right, so you filed your petition for writ of prohibition, and then shortly after that, how long after that did you file your motion for stay?
The motion for stay in the circuit court?
Well, yeah, I think it should have been filed before the county court as well, to ask the county court to just stay any further proceedings until you could get your writ heard. But you said it was filed in the circuit court. How long after you filed your petition?
The same time. It was filed at the same time as the petition, and when I showed up for the hearing, for the evidentiary hearing,
Okay, so you filed your petition and your motion for stay at about the same time?
At the same time,
At
yes.
the same time?
The circuit court order dismissing the petition makes reference to a second motion for stay of the trial court proceeding. So there were two filed.
Yes, I believe so, Judge. The petition was filed before the evidentiary hearing, and then the circuit court did not enter an order until June 21st, 2006. So everything that was supposed to occur, such as the sentencing, should have occurred already, but it obviously did not. So there were several motions to expedite the review of the petition filed in an effort to get an answer as to the circuit court's, basically an answer to the petition, whether they would hear it. So we would argue that this appeal of the petition, of the order denying or dismissing the petition, is our only and our best remedy at this point. We obviously cannot file an appeal, a direct appeal of the judgment and sentence. Our only remedy is to prevent the county court from actually sentencing Mr. HEBENSTREIT after he was acquitted. And this, the judge's basis for having the evidentiary hearing itself was the case of State v. Blasey, which was a second district court case in 1981, in which the jury had, I guess, signed the wrong jury form, but before they were actually dispersed into the community, it was discovered that there might be an error. So the judge did not know that there was an error at the time they were discharged, but knew before they were actually dispersed into the community, had them sequestered an additional night, brought back to the court, and in open court, they discussed this alleged error. In this case, the judge realized that there could have been an error before discharging the jury, and in fact said that the jury has reached a verdict, and to poll the jury to see if they've changed their mind creates a double jeopardy issue as far as I'm concerned. The judge knew that there might be an issue, and instead of addressing it at that time, discharged the jurors. They were free to go out in the community. 2 days later, he does an order recalling the jury for almost a month after that. And at that point, you know, there had been media attention on this case. All of the jurors, you know, testified at the evidentiary hearing as to that. And at that time, the jurors had been contaminated. And that's the difference between State v. Blasey and this case. The judge is essentially appealing his own order. I mean, he made an order that he wasn't going to address this and wasn't going to keep the jurors and explore that issue, and then 2 days later decided to revisit the issue. But it was too late. Mr. HEBENSTREIT was acquitted, and after an acquittal, there was no jurisdiction for the the county court to recall him for any hearing whatsoever, and at this point to have him seized and brought before the court for sentencing.
Why did you wait 15 days? On April 25th, the county court issued a notice of evidentiary hearing, and you didn't file your petition until 15 days later, 15 or 16 days later on May 10th.
That's correct, Judge.
And then, I mean, it was, and then the very next day they held the hearing.
That's correct.
Perhaps if you had filed it a little bit sooner, that you know, you may have had a different outcome. But I was just wondering, is there anything in the record that indicates why you waited so long?
No, Judge. I think it was just trying to determine what we were going to do at that point, trying to get a hold of the Mr. HEBENSTREIT and things like that. I don't have an answer as to why it was filed on May 10th, and that's why the stay was so important, and that's why I filed it in the circuit court and the county court, trying to...
You filed the stay in the county court as well? When did you
Yes.
file the stay in the county court?
I'm sorry?
When did you file the stay in the county court?
The county court on the day of the evidence.
Same day? On the
Yes.
day of the evidentiary hearing?
That's correct. So, realizing that it should have been filed a lot sooner, and that, you know, obviously the circuit court wouldn't have time to address the issue and then get back to prevent the evidentiary hearing.
You're down to about a minute and a half if you want to save it.
Thank you, Judge.
May it please the court, my name is Pam Kohler. I represent the state of Florida in this case. Obviously, at the state's position, the circuit court ruled accurately. You
Ms.
can't
Kohler,
undo.
what bothers me just a little bit is the fact that the petition was filed before the evidentiary hearing. They also requested a stay of the proceedings before the evidentiary hearing, although the stay, maybe it was appropriate to file it in both the circuit court and the county court. But in any event, all this was done before the evidentiary hearing was held, and then the next day they held it anyway. And it kind of bothers me that a petition for writ of prohibition can be circumvented by simply going through with the hearing after the petition has been filed and then declaring, well, it's moot and therefore the petition should be denied.
Well, number one, according to the record on appeal, the petition for writ of prohibition was filed May 9th. The hearing was obviously set for May 11th. It was not filed as an emergency petition for writ of prohibition.
But they requested a stay, too.
The next day, according to the record on appeal, May 10th, the day before the hearing, an emergency. Now, I don't know when they got that.
And so all the trial court needs to do to circumvent the petition for writ of prohibition is simply hold the hearing anyway. Deny the request for stay, hold the hearing, and then it's declared moot. I mean,
Well,
is that really the procedure that should be followed when these petitions are filed, or should you hear the petition first?
Well, obviously, the better procedure would be to have some sort of a situation where a petition for writ of prohibition, especially if one were filed as an emergency petition for writ of prohibition, is brought in front of the court immediately so that something can be done and it can at least be ruled on. To be honest, I don't think it would have been granted anyway. Under the Blasey case, the judge properly recalled the jury and found the defendant guilty in this case. This was simply a mistake in recording the verdict. It was not any other sort of mistake. So I don't know that there's any harm in this case, just because obviously the better procedure is to have the circuit court look at it before the hearing's over. And I don't know if there any sort of bad intent or by the court in this by holding on to it, but I mean, it was.
Well, is there any time frame that's unreasonable? You think it's fine to bring the jury back 28 days later and correct the verdict? Could you bring them back 6 months later? Is there any? I mean, what are the limits on this?
Well, what the court's concerned about is some sort of taint, that the jury's been tainted. In this case, the trial court found out that very same day that the verdict was rendered that it was the wrong verdict. That they said, oops, he's sitting there rendering the verdict, and the foreperson's trying to get his attention, the bailiff's trying to get his attention, the state asks that he pull the jury afterwards, and he keeps dismissing everybody. He says, no, I'll talk to you later. Afterwards, he talks to them and realizes, oh, they rendered the wrong verdict. He doesn't think he can do anything at that point. Apparently, 2 days later, decides he can. He issues an order for a hearing to recall the jury.
But you cite to the Blasey decision, and that was a decision where the jurors went to the hotel and they were brought back almost immediately when the mistake was discovered. Here, there was almost a month between the discovery of the mistake and having the jurors come back for the hearing.
I don't see the difference.
Can you cite to any case where the verdict was corrected after this length of time transpired between finding out about the error and having the jurors come back?
Well, obviously, these are very unusual circumstances, and this almost never happens, thank goodness.
Isn't it true that the cases that are out there basically deal with a very short period of time, minutes or maybe hours at the most?
But that goes to whether or not the jury's tainted, whether or not somehow they've been influenced by outside forces. That's the whole goal in that. In this case, we know the jury wrongly checked the not guilty line, that they meant to check the guilty line.
We know that because of what came out at the evidentiary hearing 28 days later.
No, we knew that because of what the judge told the attorneys the day it occurred.
Well, then why was there a need for an evidentiary hearing? What was the evidence for? You wouldn't need an evidentiary hearing if you were going to rely on the judge telling them what the jurors told them, right?
Well, he wanted to recall the jury. It was actually an order setting a hearing to recall the jury, and that's what she moved to preclude.
And did they take evidence from the jurors at that hearing?
Presumably.
Okay.
I mean, I think you want to put it on the record.
Okay, so it is significant what they said 28 days down the road, presumably, right? Because otherwise there would have been no need to have an evidentiary hearing, right?
But nothing had changed. I mean,
how do we know that nothing changed? How do we know that the jurors testified 28 days later the same way they would have testified 28 days earlier?
Because it was the same verdict. I mean, they all told the judge on the day this happened, whoops, we meant to check the other line. We didn't mean to check the not guilty. 28 days later, they came back and said the exact same thing. Presumably, we do not have the transcript from that hearing here.
And there wouldn't have been a transcript with the judge's informal conference with the jury.
True. And you have to take the judge's word for it. I guess you could put him under oath and make him.
I was going to say, the trial judge is essentially a witness at this point to indicate that the jury immediately after the trial said that and what they said and that they all said it, and that then the hearing on the evidentiary portion of that wasn't held for 24, 28 days later.
Well, I mean, it's clear the judge messed up in this case. I mean, he should not have, number one, as soon as someone was trying to get his attention, he should have stopped and found out what was going on, or at least allowed the jury.
I think we all agree that polling would have been the best thing to do at the time.
And the state tried to do that.
Right. And we're not blaming the state here for this. The question is, and I want to get back to this, the narrowness of what we're here for.
Correct.
We're here for a writ of prohibition as to holding an evidentiary hearing, which was already held.
Right.
Now, at this point, it's not right for a final appeal because the sentence hasn't been rendered. Is that
true? But, I mean, to be honest, what's the purpose of stopping the sentencing at this point? I mean, he's already been adjudicated guilty. He's been found guilty by the jury. So why, I mean, and plus he's got an adequate remedy at law. If you find him good, go ahead and sentence him. Let the circuit court deal with it on appeal. I don't see how that's not an adequate remedy at law. That's all the circuit court said.
Well, if he's not released pending the appeal, I guess it's not an adequate remedy if he sits in jail for however long it takes for some court to decide they didn't have the county court didn't have jurisdiction to do it, right?
Well, I mean, with all appeals, you've got that issue, whether or not they have a justiciable issue or not on appeal. That's one of the basis for a supersedious bond. So, I mean, that's in every case. This is nothing special as far as that.
Well,
The facts are
that
obviously
depends on
unique,
whether you
but-
can post a bond or not. Let me get back to a prior question to you, and that has to do with the fact that the petition was filed before the evidentiary hearing was held. They requested a stay. That was denied. And your response was to me, well, Judge, it wouldn't have mattered anyway because had they had the hearing, the defendant wouldn't have obtained the relief he was seeking anyway, and he would have been sentenced. And so you cited Blasey and some of the other decisions, and we pointed out that, well, this was a unique case and maybe distinguishable because there is a big lapse of time between the time that the mistake was discovered and the time the jury was brought back. So I'm not so sure that your argument that, well, the petition would have been denied anyway is a persuasive argument to me. When it appears that perhaps the trial court should have stayed the proceedings and had the petition heard first before they went on with the evidentiary hearing, and it may have been a different outcome. So my question to you is, why wouldn't it be appropriate to say that, well, the petition should have been heard before and remanded for a hearing on the petition?
Well, but those are we don't have those facts, and I mean, it wasn't done in that case, and whether or not it would have been granted or not, does that make it an emergency situation where he doesn't have an adequate remedy at law at this point? I mean, obviously, to meet the requirements for an extraordinary writ are very hard. I mean, and they're intentionally made hard, that they're only supposed to be for emergency situations. There is case law to support the trial court's
You don't
position.
think this meets, I mean, they asked first, they didn't even ask to expedite it? Was there a request to expedite?
No.
But in any event, you don't think the appropriate thing for us to do, given the fact that all this had been filed before the evidentiary hearing ever took place, to say, well, the mootness argument really isn't persuasive. Let them go back and have their hearing. It looks to me like they were entitled to it in the first place, and they just kind of went on with the evidentiary hearing anyway.
Well, all we have before us right now, Your Honor, is a petition for writ of prohibition and whether or not they should dismiss it. The issue is moot at this point. The hearing has been held.
It's moot because the trial court went ahead and had the hearing anyway. So anytime you have a petition for writ of prohibition filed, all the trial court has to do is just go on with the hearing anyway, and then you can come in and argue it's moot, and that vitiates the...
He can still appeal. I mean, he still has a direct appeal in this case.
But why should he have to go through sentencing first and be confronted with the possibility of incarceration and being remanded without bond and having to suffer any time in jail when his petition could be heard that may prevent that?
But it wasn't.
I know it wasn't.
And it was not filed as an emergency petition. Maybe if she had filed it as an emergency petition, it would have been brought to the trial court, the circuit court's attention immediately.
Is there a case law out there that says if it's filed as an emergency petition that they have to stay and that, that they can't conduct the evidentiary hearing?
Of course not.
So what difference
I'm just
does it
saying
make?
that would have brought it to the attention of the circuit court to say this is something that needs to be addressed immediately. As opposed, as you pointed out, the hearing was set on April 19th. She did not file this petition until May 9th. Why not file it immediately and give the circuit court some chance? The circuit court is not the only one to blame here. It is also defense counsel, because she should have filed this immediately upon getting notice of the hearing, because she found out about the hearing the day it was set, because apparently the newspaper contacted her about it. So she knew about it immediately. She should have filed something and given this circuit court some time.
What would have happened if she filed it, let's say, 7 days before, and they went on with the hearing anyway? You'd be back in here arguing mootness again.
Well, what if she had actually filed it a day afterwards and they held the hearing? It's just...
whether she filed it the day before, 2 days before, or 7 days before really doesn't have anything to do with the mootness argument, because had they gone on with the hearing anyway and not stated, you'd be back in here arguing mootness again.
Well...
And so my question to you is,
the reality is it is moot at this point. The thing is, you shouldn't allow defense counsel to wait until a day before the hearing, file a petition for writ of prohibition, and then complain about the fact that the issue becomes moot because the day has passed.
Apparently, the circuit court found it was moot because the evidentiary hearing has occurred and presumably the petitioner has been sentenced, correct?
True.
That's incorrect.
Correct.
Correct? For all we know, maybe there are these exceptions for when you can hear even in spite of mootness. The circuit court didn't choose to do that. Maybe it makes a difference if they're informed that he hasn't been sentenced yet. Why couldn't it be a reversal because the circuit court improperly relied on the presumption that turned out to be incorrect that sentencing has occurred?
Then why doesn't defense counsel file a motion for a hearing? Why didn't she file a new petition for writ of prohibition alleging, that she wanted him to stop this resentencing?
You don't see anything procedurally that would prevent the defendant from now filing a petition for writ of prohibition to prohibit the sentencing from going forward, because it hasn't occurred yet. That wouldn't be moot, and they could make the same arguments that they could have made here if they hadn't narrowly limited it to the evidentiary hearing.
I don't see the point in that. It's almost piecemeal litigation. Basically what she was trying to avoid has already happened. He didn't want the hearing to be held and him to be found guilty because she knew and he knew that he was going to be found guilty.
If the defendant's argument on the merits is correct, then the county court doesn't have jurisdiction to do the sentencing. Would you agree with that?
Not totally, because it has to be obvious. And I think the Blasey case provides support for the trial court's ruling.
My hypothetical was, if defendant is correct on the merits, you're arguing the merits now. I'm trying to look at the procedural issue.
Okay.
Assume the defendant is right on the merits.
Okay.
And ultimately would prevail on the argument that they waited too long, the jury can't, all right.
Okay.
Their argument then would be that the county court doesn't have jurisdiction to sentence, correct?
Correct.
Isn't the improper exercise of jurisdiction a classic situation in which a writ of prohibition is in fact an appropriate remedy? You don't have to wait for them to do everything and then argue on appeal they didn't have jurisdiction. That's one of the reasons you use a writ of prohibition, isn't it?
Sure, it's for speedy trial demands, things like that, where speedy trial or the statute of limitations is run on a case, and so you don't want to proceed with the prosecution.
And so if the argument is they're exercising jurisdiction they don't have, then writ of prohibition is an appropriate remedy. You don't have to wait till they sentence you and then appeal the sentence, correct?
But I think it is an arguable issue that the trial court had jurisdiction in this case because the jury's verdict was actually guilty.
The problem is that I think there's case law out there that says that once the person is essentially convicted, that the trial court has to proceed with sentencing, doesn't have any alternative, and then is automatically vested with the jurisdiction to sentence.
True.
That would be my concern about that, but
true. Once he's found guilty,
I'm still bothered by the fact that they, that all the petitions and the request for stay was filed before they had the evidentiary hearing that went on with it anyway. But you seem to say that, well, they didn't know about it.
It's my recollection that, circuit courts are pretty busy. Maybe nobody brought it to their attention.
Maybe, I don't know.
Or I don't know if she asked for a hearing, if she asked that it be set for a hearing. That's
right.
obviously. Thank you.
Thank you.
Judge, first of all, I just checked the record, and the request for the stay was filed in the circuit court. The motions that were filed in the county court on the day of the evidentiary hearing, it was not a stay. The stay in the county court was filed before the sentencing hearing, so I apologize for that mistake. But to address what the court's questions were, that is the problem, is if the circuit court ignores the emergency motion to stay.
Are you aware of any cases where that was done, that, the petition for writ of prohibition was filed, the request for stay was filed before the evidentiary hearing took place, and they went on with the evidentiary hearing anyway? Are you aware of any cases that say that, well, perhaps the appropriate relief would be to go back and allow the hearing on the writ of prohibition as if the hearing didn't take place, or do all the cases say despite that it's moot anyway? Are you aware of any cases that might be on your side in that instance?
I'm not aware of any cases that are on my side in that instance. It does appear that once, because prohibition is to prevent something from happening, that once it's happened, then it would be moot because you have another adequate remedy. Which would be
so what is it specifically that you're asking us to do?
Judge, I'd be asking this court to either issue a writ of prohibition to prevent it's a formal judgment and sentencing. The verdict was changed, but there's no formal judgment and there's no sentencing, or to reverse and remand to direct the circuit court to do so. That the order dismissing the petition is erroneous anyway, because it does say that sentencing has presumably occurred. So they're obviously trying to address the fact that sentencing could be a reason to prohibit the county court from going forward. The distinction is that an evidentiary hearing was before the petitioner at the time that the petition was filed, and everything went anyway, and the stay was filed in the circuit court. They did an order to show cause why it shouldn't be dismissed as moot. That was answered, that sentencing had not occurred, that the jury had changed the verdict, and they then waited until after May 30th when the sentencing was supposed to occur, and then came back and said, well, sentencing has already occurred, presumably. So, it does seem that, I don't know whether it's the circuit court not having it together to, when it comes to appeal, appellate matters, but they did wait until everything was done to respond every single time. And there were emergency motions to expedite, emergency motions to stay, everything that the petitioner appellant could think of to get an answer on the process to determine whether there was going to need to be an appeal, a formal appeal. But a notice of appeal was filed in this case after this appeal was filed, just to cover the bases for the appellant. But obviously, without a judgment and a sentence, that is not right for review yet.
Thank you, counsel. Your time's expired.
Thank you.